With that bit of introduction, what I want to do now is go straight to the rules. And so, we begin with the very first of these rules. The competent patients have the right to refuse medical treatment, period. If a competent patient says, don't treat me, hey, here's the thought, don't treat them. We don't treat patients because we want to. We treat patients because they consent to treatment. And without the consent, we provide no treatment. The decision maker in the setting is not the doctor, it's the patient. And a patient who's competent gets to say no. You understand? There's a clear corollary to this rule. Namely, patients get to make stupid decisions. Because you know that's what's going to happen on your exam question. They're not going to present you with patients making decisions you like. They're going to present you with patients making decisions you don't like. And you're not going to want to follow them, but the right answer is to follow the patient's wishes. The simple fact here is you don't have ownership and control of the patient's body. They do. And whoever owns, controls. I own my body, I get to make decisions for me. The patient owns his or her own body, they get to make decisions for them. Competent patients have an absolute right to refuse treatment. That's the rule. But wait, every rule has exceptions, right? That's pretty much a rule in and of itself. Every rule has exceptions. And so, here are 4 exceptions people go to court arguing for all the time in the real world. They say, I'm not going to listen to the patient because I need to preserve their life. Life, the highest good, once gone, can't be replaced, so I must disregard the patient's wishes and intervene in order to preserve their life. Or, people go to court arguing to not do this simple, obvious treatment. It's the same thing as, well, helping the patient commit suicide, right? I mean, I'm not going to help the patient kill themselves, so clearly this is the same thing. It is, quote, the moral equivalent of suicide. Or, for the sake of third parties. This man is refusing treatment and therefore might die. And if he dies, then his 4 adorable children here will be destitute orphans. For their sake, I must intervene. Or, the professional canon of my ethics. I took an oath, and because of that oath, I'm required to intervene. Because of that oath, I must intervene because my ethical obligation requires it of me. Hey, these are all good arguments, strongly reasoned, passionately felt, and I list them for you explicitly so I can now say this next sentence to you. On the exam, indeed in real life, none of these exceptions work. If you thought these were good reasons not to listen to the patient, I'm telling you as well as I can, eyeball to eyeball, none of these exceptions work. So let's be clear. The patient is refusing treatment. Without this treatment, the patient will die. What's the medical outcome we now expect? Well, that's easy. A corpse. The patient will die. If you think the greatest good on this exam is saving the patient, you're not listening. The greatest good is listening to what the patient says. Please note, refusing treatment is not the same thing as committing suicide. Saying no to treatment is not the same thing as an affirmative life-ending action. Courts have not considered it the same, and therefore we can't consider it the same. And we don't treat people for the sake of third parties, we treat them for their own sake. Finally, nobody cares about the canon of your ethics. You're not the decision maker. The patient's the decision maker, and we're going to go with what the patient decides. The first rule is an important one. Competent patients have an absolute right to refuse treatment. Rule number 2 reminds us that a feeding tube is a medical treatment and therefore can be withdrawn at the patient's request. If a patient doesn't want a feeding tube, we simply remove the feeding tube, even though it might have been in place for months or years. Removing a feeding tube is not considered killing a patient, as is sometimes construed. Removing a feeding tube is considered termination of treatment. And since decisions to start or to stop treatment are not the doctor's, but the patient, a patient can have a feeding tube removed. That means competent patients can refuse even life-saving food and water. Now, folks, those who have spent any time in oncology units know this happens all the time in the real world. As the patient's cancer spreads, they don't want food, we don't give them food. They don't want fluids, we don't give them fluids, and then they quickly die afterwards. Please note, this is not considered euthanasia. This is not considered assisted suicide. This is considered the patient having the right to refuse treatment, and giving food and water can be construed as treatment. What about the sometimes troubling case of anorexia nervosa? Well, I have to tell you at the outset, this is not really an issue on the Step 2 CK exam. I'm going to talk my way through this, but this has never actually been featured on a question on the exam. The issue for anorexia nervosa is straightforward. These are patients that are refusing food and maybe even fluids. In other words, the refusal of food is itself a pathology. Well, first, this isn't really as much of an issue empirically in the real world as you might think, because as you should recall, the age of onset for anorexia nervosa is in the teenage years. In the teenage years, the person is a minor, they're not an adult, they're not making decisions for themselves anyhow, somebody else is making decisions for them. But let's make it a hard case. Let's make this a 19-year-old woman with severe anorexia nervosa. Well, the outcome for this is going to violate one of the other rules I'm going to give you. This is an exception where we're actually going to go to court. A judge is going to decide this woman's incompetent, and based on that judge's decision, we're then going to turn to the person he appoints as the medical guardian of this patient, and that person will make medical decisions. Please note, this is a very easy court decision because anorexia nervosa, you recall, is a manifest condition. The patient is very painfully thin. It's not a hidden condition. It's obvious to the judge what is going on. All of that said, to address issues that students have sometimes asked, this is not really an exam issue. The real exam issue is a competent patient can refuse even life-saving food and water, even unto death. Number 3, I said a competent patient has the absolute right to refuse treatment. So clearly, the next issue we must resolve is how we determine competence. Oh, that's easy. On the exam, indeed in real life, we assume the patient is competent. Patients don't have to prove to you they're competent. You have to have clear, objective evidence that they're incompetent. And if you don't have that evidence, then they are competent. We don't have to demonstrate competence. We have to demonstrate incompetence. That's the way I want you to think about this. What I'm trying to do is make your lives easy. If a patient's clearly incompetent, everyone can tell. If a patient's clearly competent, everyone can tell. But then there's that gray area in the middle where you're just not sure. I just removed the gray area. There is no gray area. Because if you're just not sure whether the patient's competent or not, what's the answer? They are competent. There is no fence to sit on. If you're not sure whether or not your patient is competent, you assume competence. Diagnosis, please note, by itself tells you zero about the patient's competence. And the reason is competence is not a medical decision. Competence is a legal distinction. And you, doctor, I'm sorry, are not qualified to determine competence. Nor can you get a psychiatric consult to determine competence, because a psychiatrist is not qualified to determine competence either. Psychiatrists can give you a psychiatric diagnosis, tell you schizophrenia, tell you bipolar, but they can't determine competence. Competence is a legal distinction. So you have a patient, severe schizophrenia, been in an inpatient psych ward for the last 4 years, been maintained on large doses of risperidone over that whole time period. Is this patient competent? Yes. The beginning association must be yes. If that's all you know is diagnosis, assume competence. An 87-year-old woman with severe Alzheimer's dementia. She's been in an inpatient care unit where she's getting 24-hour nursing care and supervision over the last 3 years. Competent? You must assume yes. If all you have is diagnosis, the assumption must be competent. A patient comes in the emergency department, the question says, obviously stumbling drunk. Competent? You must assume yes. The standard is very clear here. Can you get and give information? If you can, assume competence. But I'm not sure that this drunk guy understands what I'm saying. And since I'm not sure, I assume competence. If you're not sure, it doesn't mean he's incompetent. If you're not sure, it means he is competent. You ever talk to someone who's drunk? Can you get and give information from someone who's drunk? Yes, you can. And so here we go again. Assume competence. How do you know somebody's incompetent? 2 ways. First, a legal designation. A court can tell you someone's incompetent. But secondly, clear, manifest behavioral evidence that anybody looking at it would pretty much agree the person's incompetent. So as I'm interviewing my schizophrenic patient, he begins to babble incoherently, foam out of the side of his mouth, falls to the floor, flailing rhythmically on the linoleum tile. Competent? No. Any 20 people I bring off the street and I ask the question, they're all going to tell me this guy's incompetent. Could it be competent today and incompetent tomorrow? Yes, and he could be incompetent today and competent tomorrow. But in that episode, he's certainly incompetent. The ambulance pulls up the emergency department, brings in a patient whose left arm is a tattered mass of flayed skin, exposed bone, spurting blood. This person slaps himself with a razor blade 35 times as part of a suicide attempt. As you're trying to staunch the flow of blood, save the patient's life, the patient is heard to say in a clear, loud voice, "No, I don't want treatment, let me go." Do we keep treating the patient? Of course we do. Why? Because trying to kill yourself is clear evidence of incompetence. It's a rule. You try to kill yourself, you basically hung a sign around your neck that says, "Hi, I'm incompetent, so go ahead and act accordingly." We don't help people to kill themselves. We don't allow people to die after an attempt to kill themselves. We intervene despite whatever they say. But if you're not sure in the exam, if you're sitting on the fence, you can't tell one way or the other, it's clear how you have to go. Assume competence. Can you get and give information? If yes, then the patient is competent. Competence is not taken away quickly and easily. It's taken away as a last resort. And understand why. If you could decide a patient's incompetent quickly and at a moment's notice, well then, they're not the decision makers anymore, are they? And please understand, patients making bad decisions, that by itself is not evidence of incompetence. If it were, once again, the patient wouldn't be the decision maker. It would default to the physician to determine whether they made a good or bad decision. A competent patient has an absolute right to refuse treatment. Rule 1. How do I know a patient is competent? Assume they are. Rule 3. Rule 4 reminds us, what many of you already know, special rules apply with children. I know everyone's concerned about the exceptions and the wrinkles here, and we will talk about those, but I want to begin our discussion with the fundamental starting line, namely, anybody under 18 years of age is incompetent, period. 17 years, 364 days old, they're incompetent. Nothing they say matters. Next day, they have a birthday, they're 18, they're fully competent. Everything they say matters. It's that cut and dried. You don't accumulate competence as you approach your 18th birthday. You have none, and then, given the 18th birthday, you have it all. Basically, what I've said is, over 18, we assume competence. Under 18, we assume incompetence. That's the starting point. Now let's talk about the exceptions. The first exception is emancipated minor. Emancipated minor, most states, we're talking about children aged 13, 17, they're living as adults, acting as adults, caring for themselves as adults, and so we treat them as adults. That means they have full adult rights and decision-making abilities. There's two ways to be an emancipated minor. De jure, a court has designated you as being emancipated, or the more common, de facto, you have, by dint of your behavior and experience, demonstrated that you are responsible, so we consider you an emancipated minor. It's possible to be an emancipated minor and still be living with your parents. It's not that common, but if you're living with your parents, contributing to the household in an adult-like fashion, contributing money to take care of the rent, utilities, being like an adult member of the household, you can still be emancipated living with your parents. That said, usually emancipated minors will no longer be in their, what we call home of origin, will no longer be living with their parents. Emancipated minors, we treat them as full decision makers. They are considered competent in the eyes of the law. How will you know in the exam that someone's an emancipated minor? They will tell you they are, and you'll accept what they say. The rules of the question writers say you can accept anything presented in the question at face value. Do not second guess. If someone says they're an emancipated minor, go with that. Now, they won't use the phrase emancipated minor because most people in the real world don't really know and use that phrase. But it might be as simple as a 15-year-old boy comes in, he's been in an automobile accident, you believe he has a green stick fracture in his left arm, you tell him, I need your parents' permission to do the x-ray, which you of course do, and he says, I'm not going to tell you who those people are, I haven't seen them for years. Ooh, let me translate that for you. I'm an emancipated minor. You're going to go ahead and treat him, do the x-ray based on his permission because he's presented himself as an emancipated minor. Don't worry about whether or not he lied. Take the information at face value. The following things by themselves render you emancipated. You're married, you're emancipated. I know it doesn't seem that way, but go with me on this. If you're married, you're emancipated. If you're in the armed services, you're emancipated. You're 15 years of age, sir, you're big for your age, you lied, and now you're Marine. Well, congratulations, you're Marine, and you're also emancipated. The following things by themselves do not render you emancipated. You're pregnant or you have a child. Getting pregnant demonstrates no adult-like capacity. In fact, one could argue the opposite. Having a child doesn't demonstrate adult-like capacity either. Is it possible to have, for example, a 16-year-old girl who lives at home with her mother and has a 1-year-old child who is emancipated? Yes, it is, but it's not the child who emancipates. It's the other things you read about the girl's behavior. If this girl, for example, goes to school, does her homework, goes and works as a waitress, takes the money, contributes to the household pool of finance, and helps support the family, even though she's in school, she may well be considered emancipated. If, on the other hand, she goes to school, comes home, does her homework, goes to bed and gets up and does it again the next day, she's almost certainly not going to be considered emancipated. That means if I have the 1-year-old daughter of the 16-year-old girl who requires medical attention, who's going to make the decision for that 1-year-old daughter? Well, probably not the mother, the 16-year-old girl, probably the woman who is likely the guardian of the 1-year-old, the girl's mother, that is the grandmother for the 1-year-old child. Emancipated minors, remember again, are full adults in the sense that they can make all adult decisions. So that clearly means they can make medical decisions. If you have an emancipated minor and the question is who is going to make the decision for this medical procedure, the answer, of course, is the patient themselves. Being emancipated is being competent. The second exception is called partial emancipation. Partial emancipation you get by having your 15th birthday. You don't have to demonstrate any adult-like capacity or responsibility or maturity at all. You just have to have the birthday and bang, you get the right to make medical decisions for yourself in 4 areas, but these 4 areas only. What are the 4 areas? Sexually transmitted disease treatment, substance abuse treatment, birth control, and prenatal care. That's it, but those are important areas. Now, why these 4 areas? Well, look at them again. A moment's reflection tells you these are issues of serious public health consequence. And so we want to make sure that people do the right thing, and we're afraid that if they needed parental permission, they would not do the right thing. We're afraid, for example, the 15-year-old boy with gonorrhea won't go to his father and say, "Dad, I have gonorrhea, I need to see the doctor," that he might just try to tough it out anyhow. And so we let him go to the doctor and get treatment without the parents being involved. Now please note, these 4 areas only. I can't treat a child for the common cold, for influenza, without the parents' permission. But I can treat them for these 4 areas without any parental involvement. Okay, with that in mind, let's try a simple case. A 16-year-old girl comes to see you. She's been your patient for the last several years. She's coming to see you to have a physical exam prior to going to summer camp. You give her the standard physical exam, and finding nothing out of the ordinary, you're sitting at your desk completing the paperwork that she's brought for you to complete. As you're filling out the paperwork, she finishes getting dressed and interrupts you, saying, "Doctor, there's just one more thing. When I go to summer camp, I'm going to go with my boyfriend, and we've decided we're going to start to have sex. So please, will you also, since you're writing there, write me a prescription for birth control pills? And by the way, you can't tell my parents. They wouldn't understand." The question, of course, stops at this point and says, what action should the physicians take next? What do you think? Well, you're thinking, I'm going to sit there and write her the prescription. Sorry, you just missed the question. Because, yes, by law, you can write this 16-year-old girl prescription for birth control pills, and yes, you can give her the pills without telling her parents. All that's legal, but that wasn't the question. The question isn't, can I write her the prescription? The question is, what should the physician do next? Do you honestly think that if you simply hand the girl a prescription and wave her goodbye, we're going to give you a point for doing that? Let's rewind. Let's go back and think about the situation one more time. Here you have before you a 16-year-old girl who's so much going to become sexually active that she wants a prescription for birth control pills. What do you need to do here? Not simply hand her the prescription. You need to give her information, some counseling, advice, tell her about other options such as barrier methods, because there's more at stake here than simply avoiding pregnancy. Once she's fully informed, she can now make the usual consensual decision. And if she still wants to opt for the birth control pill, she can. But we can't write the prescription until that fuller discussion has in fact happened. Now, by that example, I want you to pick up two things. First, I want you to remember what the rules are, but secondly, I want you to notice that you have to answer the question, not simply regurgitate the rule. The question wasn't, can I write a prescription? Of course you can. The question is, what should the physician do? And more needs to happen there than simply writing the prescription. Rule number 5, an important rule we alluded to previously. Parents cannot withhold life or limb-saving treatment from the children. Can't do it, it's not allowed. Doesn't matter why the parents say no. If the child, quote, needs, unquote, the treatment, we will do it despite the parents' objections. So this now gives you a clean answer to the question where we have parents who, for religious reasons, do not want the child to have a blood transfusion, even though the child needs this life-saving procedure. Of course, we transfuse. We ignore what the parents say, we transfuse. Why? Because parents can't withhold life or limb-saving treatment from the child. You're not allowed to beat your child, starve your child, deprive your child of necessary medical care. Please note, when we're ignoring somebody's wishes that are founded on religious principles, we're not doing that because we are disrespecting their religion. We're doing that because there's certain things you're simply not allowed to do, including depriving your child of necessary medical care. Please note also that I didn't say do whatever you want with the child. I said you have to listen to the parents unless it's a life or limb-saving issue. I want to be clear with you that parents are the primary decision makers for their children. They are universally the guardians for the children, and therefore the person you should turn to. I have a child who I believe would benefit from a surgical procedure. I asked the mother for permission to do the surgery, and the mother says no. I asked the father for permission to do the surgery, and the father says yes. The question, of course, is, do I do the surgery or not? And the answer, I hope, is clear. Of course I do. Because the question is simple. How many permissions do I need? 1. How many do I have? 1. Go ahead and do the surgery. You're not required to get a consensus of the family. You're required to get a permission. You have it. Go ahead and do the action. Number 6. Number 6 is an easy rule. Don't go to court. The option you're going to see on the list that says go to court, don't pick that. It's simply there to distract you. The reason why you're not picking going to court, it's not that going to court's a bad idea. We do this all the time in the real world. It's just a bad answer on the exam. See, what the examiners want to see is how you make decisions. And when you've gone to court, you haven't made a decision. You've avoided the decision. You've passed the decision to somebody else as opposed to making it yourself. Don't go to court. Make the call yourself. And by the way, while you're not going to court, you also should not, 1, seek legal counsel, 2, talk to the ethics committee, 3, seek guidance from another physician. All those are wrong as well. Again, it's not that those are bad things to do. Those are simply bad answers on the exam. The exam is about testing your, keyword, judgment. They want you to make the judgment. They want to see what judgment you come to. Make the call and get rewarded for the call that you make. Rule number 7 is actually one of the most important rules on the list. Rule number 7 reviews not only important decision-making rules, but also tells you how they fit together, gives you a sense of a sequence and a hierarchy. The rules tells us that when surrogates, that is guardians, etc., are making decisions for patients, they have to use one of the following criteria, and this is crucial, in this order. Again, surrogates don't get to decide what they want, they get to decide what the rules say they need to decide. The first criterion the surrogate needs to use is called subjective standard. This says simply what has the patient said in the past. We sometimes use a phrase that means the same thing here, advance directive. If you have clear previous historical statement of the patient's wishes, you simply follow it, right? And you're done. Suppose you don't. Suppose the patient never said anything about what their actual wishes were. Nobody can recall, no document exists to testify to what the patient's wishes are. Well, then we fall down to, remember Karen Ann Quinlan, substituted judgment. Substituted judgment says we turn to the person who knows the patient best, and they will estimate for us, based on their experience with that person, what the patient most likely would want. Please note, substituted judgment is not a report about what the patient said, it's a guess about what their wishes likely are. But suppose nobody knows you. Suppose you're a stranger in the issue parts and nobody knows anything about you. Well, then we fall to the third and final option, the best interest standard. Remember, the best interest standard, we're simply weighing the benefits versus burdens and doing what the rational person would do under these circumstances. The key here, remember, is not to decide whatever you want, but to decide what that simple moral calculus, benefits versus burdens, tells you you're supposed to do. Now, the point here is you may see all of these as decision-making rules within a single question stem. Your job is to deal with the first rule that works, and then you never get to the next one. So concretely, there will never be a circumstance where you'll say to a patient, well, I hear what you say, but because of the best interest standard, I'm going to do something different. Why? Because if you hear what the patient says, there is no best interest standard. We're going to apply the first rule that works, and then we stop. Let's try to apply this to a fairly complicated, but I hope illustrative case. An 87-year-old woman is brought in the emergency department by her adult daughter who'd been tending to her mother at her home. The 87-year-old woman is unconscious, as soon as diagnosed as being in a persistent vegetative state. You're trying to decide how aggressively you should treat this woman. Examination and consultation by neurology suggests that with aggressive intervention, you can probably sustain her life over the next several months, if not longer. Although without the kind of very aggressive intervention, she's likely to die in a matter of days. As you sit with the daughter talking about what action you should take, the daughter is visibly upset and distraught. Asking for what should happen, the daughter says, look, doctor, Mom never said what you want done. I'm just not sure. Again, you press her for an answer, and she says, look, if I had to guess, I say we shouldn't do anything very aggressive because, well, Mom said she didn't want to drag this process out. At this point, into the emergency department burst your patient's adult son. The son had been somewhat estranged from his mother over the last several years, living out in the state of California, some 2,000 miles away, but raced to the hospital upon hearing about his mother's worsening medical condition. He seems obviously upset and demands that you do, quote, standard of care at once, pointing out that you haven't even done what is usually considered standard of care at this point. I insist that you begin treatment immediately, he says. At this point, what action should the physician take? Well, let's see. We don't have clear subjective standard. We have no sense at all. No one's representing to us what this woman's, our 87-year-old patient's woman's wishes are. So subjective standard is off. That brings us to substituted judgment. Now, simple question. Who do you believe most likely knows the current wishes of the patient? The adult daughter who'd been living with her mother, caring for her, or the son who is estranged out in California? Well, most people, the obvious answer seems to be we're going to go with the daughter, and so we will, and that's the answer to the question. Please note, having the son and daughter come to a family consensus is not an acceptable option, because it doesn't matter what the family consensus is, it matters what the mother's wishes are. Remembering again, family doesn't matter. The only time we turn to the family is when they're able to represent the wishes of the patient. Family has no standing in their own. Let's also understand that in exam questions where there, quote, appears to be conflict between family members, there's no real conflict because by the rules, one family member probably wins and the other one loses, as in the present case. Suppose the son now reaches into his pocket, though, and pulls out a crumpled, somewhat dog-eared letter. The daughter gasps because she recognized the handwriting on the letter as being that of her mother's. The son hands you, the doctor, the letter. You open it and begin to read. It says, oh, Johnny, I'm sorry we've been apart. I hope we have a chance to reconcile. Oh, and should I ever be in a persistent vegetative state, she talked like that, you know, I hope they'll keep me alive for as long as possible. Now what? Oh, that's easy. Because now with this letter in hand, we have clear subjective standard. We have a clear written expression of the patient's wishes, substituted judgments off the table. We're now going to act based on the letter, not act based on the daughter's representation. What I'm trying to impress upon you by presenting this somewhat elaborated case is that even in these seemingly confusing, convoluted circumstances, there's a clear rule that gives you a clear answer. In each of these presentations, there's a clear decision rule that makes it clear what it is you're supposed to do. Rule number 8. Rule number 8 reminds you if the patient is incompetent, the physician may, indeed I'll say should, rely on advance directives. Remembering that advance directives is a synonym for subjective standard. Okay, that's the base rule. You're going to try to follow what the patient's historical wishes are. Here's the key exam issues. First, oral is enough. In order to have a sufficiently binding advance directive, it doesn't have to be in writing, it doesn't have to be legally witnessed, you simply have to have an oral expression, and that's enough for you to understand your patient's wishes. If the patient says something to you, unwitnessed by anybody else, that should be enough to bind you in terms of following what the patient's wishes are. Now, a living will is, of course, what you'd like to have. A living will is a nice document where everything about what the patient wants for end-of-life care is all laid out. It says, I do want or I don't want the following things under the following circumstances. This is usually witnessed, certified, notarized. It is meant to be a legally binding document directing what should be done and then, of course, what should not be done for this particular patient. Living will is a clear advance directive. If you have a living will, you're simply going to follow it. The patient has sat down with forethought and consideration, specified to the best of their ability what actions they do or do not want taken. But let's understand there are some limitations to living will. First, a living will only applies to end-of-life care. If you have someone who is, well, maybe unconscious, maybe comatose, but not an end-of-life issue, there's some debate about, and the consensus is, the living will does not apply because it's not end-of-life care. Secondly, it is possible to have a living will that was done, maybe decades ago, that the judgment of the people on the ground is not likely to apply to this person now, many, many, many years later. With those caveats, the basic rule I want you to carry in the exam is, if you have a living will, it's a clear advance directive, clear expression of the patient's wishes, you should follow it. But health power of attorney is really what you want to have here. Health power of attorney doesn't designate what should happen, but designates who you, doctor, should listen to. If you have health power of attorney, it says this person, who I now designate, will make medical decisions for me should I be incapable of rendering my own opinion or giving you my own decision. Now, health power of attorney is in general much more powerful than anything else we've talked about because, one, health power of attorney gives somebody on-the-spot decision-making. It is not, as a living will is, a hypothetical where we're thinking maybe, I'm not sure, does this circumstance apply to what was written? But you have somebody who has all the actual data in the actual moment and can render, based on that, a clear decision. Health power of attorney also applies not simply for end-of-life care, but for any medical decision. If someone is unable to express themselves because they're in some sort of recovery situation or even a temporary coma, health power of attorney can be applied, whereas a living will probably cannot be. The basic rule I'd like you to carry into the exam is that health power of attorney beats everything else. Health power of attorney is a trump card that beats everything else on the table, including it can, under some circumstances, even go over and above the patient's expressed prior statement. And again, the issue is the person with health power of attorney has on-the-spot decision-making. They're able to deal with not the hypothesized set of facts, but the actual facts. The problem with patient's prior statement is one can always argue if they knew what the facts were now, they might have said something different than what they said previously. Well, the person with health power of attorney has the actual on-the-spot facts and therefore is able to render an actual decision. That said, most states, increasingly I'll point out, wish to have the person with health power of attorney follow the specifications within the living will. That is, if the living will does provide clear directive, probably the health power of attorney person should follow that. That said, remembering that living wills do not cover a number of medical circumstances, the health power of attorney usually is given predominance. So, what I want you to think about going to the exam, health power of attorney is what you want to have. Because the person with health power of attorney has on-the-spot decision-making and, to quote the phrase, speaks with the patient's voice. When someone has health power of attorney, you don't have to wonder, you simply have to listen just like you're listening to the patient. The only real limitation on health power of attorney is if it directly contradicts a living will. Most laws are being changed, so that's not considered acceptable. As long as there's not a direct contradiction, health power of attorney is, of course, superior. Number 9, don't do anything to help your patient die sooner. Now, that should go without saying, but let's talk about what we really mean here. You're not allowed to help patients kill themselves, and that includes you're not allowed to give patients the means or even the opportunity to kill themselves. You're not allowed to give the patients medications such as they could use to kill themselves. You're not allowed to provide morphine vials so the patient can go out of your sight and inject themselves and therefore die. None of that is, of course, acceptable. Some physicians in the United States think there are occasions when helping the patient to kill themselves, to end their life is the way it's usually put, is considered not only an option, but it's considered the duty of the physician in terms of ending suffering. That's not a tenable position for your Step 2 CK exam. You will not help anybody commit suicide. Yes, there used to be a guy, Dr. Jack Kevorkian, running around the state of Michigan helping patients kill themselves. Listen up, Dr. Kevorkian would get these questions wrong on the exam. Now, there is a difficult thing that happens in the real world and sometimes shows up in the exam. We have a patient who is in severe pain, and we're giving them medication to deal with the pain. At some point, however, we're going to increase the dose of the medication so far that it might actually kill the patient, cause respiratory depression, and cause the patient to die. The rule I want you to carry in the exam is simple. I want you to provide maximal pain relief, do as much as you can to relieve pain and suffering. The notion that you simply can't cure the patient, there's nothing you can do is of course wrong. You can always provide comfort care, and you must do so. But we expect you to provide maximal relief of pain and suffering short of killing the patient. In the real world, if you take the pain medication over and above threshold, it produces respiratory distress and the patient dies. We talk about dual use and we forgive you. Not on your Step 2 CK exam. There'll be an option there that provides maximal pain relief short of helping the patient to die sooner, and that will be your best possible option. Number 10, the physician decides when the patient is dead. I bet you knew that already. What we're really talking about here is a conversation about the meaning of what's in the parentheses, the concept of futile treatment. And the point is that futile treatment has two separate meanings, and you have to parse these out in terms of what we're talking about. First meaning of futile treatment, you have a patient in a vegetative state, been treating for the last 3 months. Nothing that you've tried has been successful. It's now your opinion, and the opinion of the collected medical staff, that further medical intervention is simply a waste of valuable time and a waste of valuable medical resources. The family, however, representing the patient, wishes you to keep treating. What action should you take? Well, the answer is keep treating, because decisions to start or to stop treatment are not yours to make. And since the family is a representative of the patient in this context, they, representing the patient, are telling you to keep treating, keep treating. Change the case, you change the answer, of course. You've been treating your patient in a vegetative state for the last 3 months. Nothing has been successful. Trying to find some way to maybe impact the patient's status, you've been examining the literature, and you found an interesting intervention that's had some success over in the Ukraine. You decide to try it. This intervention requires the administration of set pre-prescribed doses of drugs at fixed intervals over a 2-day period that has had stunning success helping some of these vegetative patients recover and regain their lives. You decide to try this on your particular patient. You organize your staff, lay out what the protocol is, organize the drug dosages, and monitor the patient carefully so you can see if there's any impact for this medical intervention. The 2-day trial begins. As the medication is administered over the 2-day period, there seems to be no response at all from the patient. At the end of the 2-day period, there is no evidence that there's been any positive benefit at all from this intervention. You're sitting with your staff examining the physiological data. As far as you can see, there's been no response even at the points where the drugs are administered. In fact, the patient's EEG shows nothing but a flat line over the whole 2-day period. At this point, the patient's family comes to you and reports with great excitement that right now, even as we speak, a specialist is driving in from the airport, someone they've flown in explicitly to provide consultation on this, their loved one. He's had, quote, great success helping just this kind of patient to recover and regain their lives. At this point, what's the next action the physician should take? Well, that's obvious. Your patient is dead. Did you hear it? I gave you a flatline EEG over a 2-day period. What's the standard? Flatline over 1 day. So your patient's not only dead, he's dead twice. The right answer here is basically call time of death and start disconnecting all the life support. The option says wait until the specialist come in and examine the patient is clearly unnecessary because the patient's dead and we don't treat corpses. What I have in mind by these two cases I'm presenting is a key distinction in the understanding of the idea of futile treatment. It's the distinction between lack of hope, you don't get to make that call, and lack of life, we pay you to make that call. When you think there's no hope and therefore we should stop treatment, you have to keep treating if that's the patient's and by extension the family's wishes. If you think the patient is dead, it doesn't matter what anybody says anymore, we simply don't treat corpses.